Hello, and welcome to MidPenn Legal Services presentation, Protection from Abuse in a Time of COVID. That help is still available. MidPenn Legal Services is a legal aid nonprofit. We serve 18 counties in central Pennsylvania. We are the civil emergency room for individuals who need assistance in civil legal matters, as well as individuals who are victims of sexual and domestic violence. My name is Paul Edger. I am one of the managing attorneys here at MidPenn Legal Services, and I cover all services in Adams, Cumberland, Franklin, and Fulton County. To give a little explanation as to MidPenn Legal Services, we provide services in all counties that you can see on this map in red. However, all counties in Pennsylvania are covered under what's called the Pennsylvania Legal Aid Network, which we are an agency partner of. If you reside in one of the counties colored in red on this map and you need assistance with a protection from abuse, please call our 1-800 number at 1-800-326-9177, and we will help assist you in either preparing and assisting domestic violence matters or providing information as to the partner agency that is handling those cases. The purpose of this presentation is to assist that even with this worldwide pandemic that is affecting all of us, that most importantly, help is still available. So as you've probably been very well aware, in March, the governor of Pennsylvania slowly started to shut down the state due to the increased number of this virus. But before the governor did that, the state Supreme Court of Pennsylvania declared a judicial declaration, which required each individual county in the Commonwealth to shut down cases to the public, but left open specific emergency matters. And for the purposes of today's presentation, those emergencies included individuals seeking protections from abuse, what are called emergency PFAs, or those that occur late at night or on the weekend, and those seeking it during normal court business hours to attend an ex parte hearing, or a one-sided hearing with the court. Now, the courts have been very well aware that worldwide domestic violence has excessively risen due to individuals being required to be home a lot of times with their abusers. And the courts are mindful of that as we are slowly starting to reopen the state. Courts understand that something may have occurred weeks ago, but you may not, or someone you know may not have been in a position to seek help because you couldn't due to the shutdowns. So if you have been a victim of domestic or sexual violence, and if you still need protection from your abuser, seek help now, because help is available. So one of the first questions a lot of people ask is, who can file for PFA? And what the law provides is for family or household members. And that includes a wide variety of individuals, including people that are spouses or who have formerly been a spouse, including if you've been formally divorced by a court order, or if you're just separated. And because Pennsylvania does not have legal separation, meaning we don't give you a piece of paper or a court order, we look at the facts. So even if you are separated, you are able to file protective order. Parents and children are allowed to file against each other. More likely what we see are current or former sexual or intimate partners. And please understand that a sexual partner does not necessarily mean that you have had to have sex with your partner. Holding oneself out as being a partner, even honestly, there's case law as to holding hands or a kiss is considered enough to be considered an intimate partner. But exchanging phone numbers, talking on the phone once or twice, probably is not enough if you did not hold each other out as a couple of some sort. Additionally, people who share biological parenthood, which means siblings, and then those that are related by blood or marriage. As lawyers, we like to use fancy Latin terms, what we call consanguinity or affinity. So this is going to apply to your half-sibling, your step-siblings, your stepfather, those related by marriage, including then step-parents and the like. Again, family members, siblings, aunts and uncles, cousins, if there's some biological connection where we can paint the map, you would be able to seek a PFA against that individual as well. Now, most importantly, if you or the person you're seeking protection from is under the age of 18, legally that individual cannot file a protective order themselves. However, a parent, an adult household member, or a guardian ad litem, which is an individual appointed to act in the best interest of that minor, may file on behalf of a minor child. So the second most important question is, where can I file a PFA? So it's going to be filed in the county where you, the person seeking a protective order, live or are employed, even if you're just in that area temporarily because you're fleeing abuse or you are there temporarily because of the shutdown right now. If your abuser, where your abuser can be served is another location, or where the abuse happened. And a lot of time, these three are the same county, but we also understand that they can be in different. So what we see a lot of times is where our client, the petitioner, lives or where the abuse occurred. Now, the most important note to keep in mind is that if you are asking the court to evict and exclude the abuser from your home, whether you live together, whether you were quote unquote roommates, or he or she stayed with you even once in a while, you must file in the county where your property resides, because that county is the only one that has jurisdiction or authority to file to evict the defendant or your abuser. So for example, I cannot go to Blair County at their court in Hollidaysburg and ask them to evict somebody from my home in Cumberland County, because the courts don't have jurisdiction. If I want to remove somebody in Carlisle, I have to come to Cumberland County's court to remove them. If you're fleeing and you just need protection, but you're living somewhere and you don't have to keep the abuser from living with you, or meaning they don't know where you live, you can file then in any county with the three that we just discussed. So what is abuse? The law defines abuse in 5 different ways, and I've on this slide broken them down to be less legalese and more understanding. So the first is attempting or actually causing you bodily harm or sexually assaulting you. Now, for attempting, this can be that they have raised their fist to you, that they made some gesture that you reasonably believe that they were going to try to cause you harm. Or if they swung at you, if they threw something at you, if they try to take some action, but they may have missed or unsuccessfully touched you, that is still enough to be considered abuse. When it comes to sexual assault, that term encompasses a large variety of criminal terminology, including rape, sexual assault, indecent touching. So if somebody harms you in a sexual manner or attempts to do that, that also constitutes abuse under this act. Another definition of abuse is placing another in reasonable fear of imminent serious bodily injury. Now, the key points here is that it's a reasonable fear, meaning would somebody else, if they were in that circumstance, would they believe that as well? Is it imminent, meaning it's about to happen in a very brief or quick time? And is it a serious bodily injury? So the laws define serious in a multitude of ways. If somebody is very frail or they're sick, and all it takes is pushing them over and you could hurt them or they could break something very easily, that would be serious bodily injury to that person. But if you were to slap me in the face, that may not be a serious bodily injury. That would probably just go more towards the first category. But placing somebody in reasonable fear can be making threats. I'm going to shoot you. I have a gun. I'm on my way. Even if they're very vague threats like you should be 6 feet under, that is placing somebody in serious bodily injury. Death does apply if they're harming to kill somebody as a serious bodily injury. The third is false imprisonment, and that is just temporarily or in a brief moment preventing somebody from being able to leave. This can be this could be something such as locking them in a closet. This could be putting somebody in a corner and saying, I'm not letting you leave until you talk to me. But that brief denial of allowing somebody the freedom to move is false imprisonment. The fourth is sexually or physically abusing minor children. I respectfully believe that speaks for itself. But the fifth is a person knowingly engaging in a course of conduct or repeatedly committing acts towards a person, including following them without proper authority, meaning they're not like a private investigator, which makes that person, provides them reasonable fear of bodily injury. Now, note it is not serious bodily injury, but if someone's doing the same thing, if they keep following you, if they keep raising their hands, if they're doing something that reasonably makes you think that they're going to harm you in some way, that's enough to be defined abuse under the Act. So if somebody has done one of these things, an individual may apply for a protective order in Pennsylvania. This slide shows what the front page of a protection order looks like. And depending on where you reside, there are either sister agencies that work with MidPenn Legal Services, or in some counties, it's an attorney from one of our offices that will assist you in preparing the petition. Depending on where you live, for example, in Mifflin County, the Abuse Network. In Cumberland and Perry County, we have domestic violence services. In Adams County, there's the Safe Homes. So if you're unsure as to what agencies or who assists individuals seeking protective orders, you can call our 1-800 number and we will help point you in the right direction or get you in touch with one of our advocates. Or please dial 211, which is the United Way helpline across the state, and they will make sure to provide you with the resources as to who assists individuals in your area. When you go to file a petition for protection from abuse, 3 specific things must always be included in the petition. The first is general information about yourself, who you are, where you live. Now, if your abuser, if you have fled or they don't actually know your physical address, you have every right to keep that confidential. You do not have to disclose information all of a sudden that your abuser does not know about. We need basic information about the abuser, what we call your defendant. Most importantly, an address for them, because we need to be able to serve them by the sheriffs that tells them an order is in place and to show up in court. And most importantly, you need to include specific allegations of abuse. Start with the most recent incidents that have occurred that makes you fearful or where you've been harmed. A big thing to note is that if your abuser has threatened or has used a weapon or a firearm in any way, even if it's a vague threat, such as, if your abuser constantly keeps a gun on their hip and he or she puts their hand on the holster, but you think they're about to pull the weapon, but they don't, that's reasonable enough. And it's important that you include it in your petition, because the threat or usage of a weapon, or more specifically a firearm, really raises the necessity for a protective order for someone seeking protection. The most important thing to note is you are not responsible for any fees at any time during the case. When you go to file the action, whether you're in one of the agencies that file them, or if you were to even file this on your own, the court will never ask you for money to start the case, not even for the sheriff's return. The law requires that they are covered by the defendant after the case has concluded. So don't worry about having to wait until a paycheck comes in on Friday, or you need a return to finalize. You can go to court. You will never have to pay any money up front. Now, the court is well aware, and the law recognizes that abuse does not always occur between 8 to 5, generally when the courts are open. If that occurs, if it's late at night, if it's on a weekend, if it's on a holiday when the court is not open, there are emergency PFA matter and procedures in place. The magisterial district judge, which is your local district judge in the area you live, there is always one on call. It may not be the one in your town, but there's at least one in your county, or what we sometimes call your judicial district. If you need an emergency protective order, you can file one with the MDJ that is on call. If it's granted, a constable will go out and serve the emergency order that night. Please understand most MDJs will do it by a video call, such as a presentation like what we're doing here. So you would have to, if you're in fear, call 911, tell them you need to file an emergency protective order, and generally they will put you in touch with whatever MDJ is on call that night. If you obtain an emergency protective order, the order expires at the end of the next business day that the court is open. Meaning, if you get one on Friday at 5 p.m., you have until Monday at 4 or 4:30, whatever time your court is open, to go through the normal steps that we're going to talk in just a moment to get a full PFA. If you don't, the PFA and the temporary order expires at the close of business the next day the court's open. If you do follow through and you get back into court, your emergency order will remain in effect, and then it'll get listed for a full hearing, just like a regularly filed PFA during the day. How you file protective order varies depending on which county you reside in. But in general, whether it's started by an agency such as MidPenn, or if it's filed pro se, meaning by you without an attorney, you will generally bring your petition to the courthouse, and you bring it to what's called the prothonotary. Some courts call it the clerk of courts, but the prothonotary, in essence, is the keeper of all civil matters. And this is a civil case. It is not criminal. It is essentially a civil restraining order that you are requesting from the court. You will bring your petition with you and go to the prothonotary. The prothonotary will then have you go before a judge, what's called an ex parte hearing, which is a one-sided hearing where your defendant and your abuser has no knowledge of the hearing and does not get to say or share anything. It is just you and the judge. You will be on the record, whether it's a stenographer typing down what's being stated, or if it's just being an audio recording for future recordings if necessary. But you will explain to the judge what's in the petition. Sometimes the petition will speak for itself and the judge has just basic questions. But then the court will either grant you a temporary order or deny it, saying you don't meet the grounds for PFA. Whether it is granted or denied, the court must list the case for a full hearing within 10 business days. So not, calendar days, but a business day. Most counties have regular PFA days. For example, in Cumberland County, we handle them every Wednesday morning. But depending on which county you are filing in will depend on what day your hearing may be. If your temporary order is denied, you still have the right to have a hearing to have the final order granted. However, if you truly do not want to proceed at that point and you don't feel comfortable proceeding for a hearing after the temporary has been denied and your abuser then being told you attempted, if you tell the court, I don't want to go through with it, most judges will honor that request and just destroy what's been stated. The law says it's supposed to be scheduled for a hearing, but the courts are mindful that it also may put somebody in a very dangerous position. But realize if it is denied, you more than likely, you do have the right to take it to a full hearing, and you could request a hearing to get a second chance with the court at that point. Once it is granted, or if it's denied and you're okay with the hearing, the sheriff will serve the petition, which is where you've alleged everything that's been abusive towards you, the temporary order, and a notice to hearing, which tells the defendant when and where to show up, and also has some important legal rights to know for them, and that is served on the abuser. And then it is required that the abuser show up in 10 business days. The final hearing must be scheduled by law within 10 business days. However, due to what's been going on in the state with COVID and the county shutting down, the judges and the counties have been much more flexible with the 10-day rule. So it may not be scheduled necessarily in 10 days. Slowly right now, we know counties are starting to open back up, but realize that you may have a county that schedules your final hearing within 10 days. You have some where it may be a couple weeks. But the most important is once you've had that ex parte, be ready for the next hearing. So, one of the most important things to do is you have the right, if somebody has firearms, the law requires that if a protective order is entered, that a defendant is to turn over all firearms within 24 hours after a final order has been entered. This document, which we call Exhibit or Attachment A, is your opportunity to list all of the guns that you know your abuser has and just a general location where you believe they may be located. So you don't have to be precise. You don't have to know what model a firearm was. It can be as quick as a shotgun is in the bedroom, a rifle is in the garage. That's all the general knowledge you need to have. The sheriffs will use that information. When they serve, they will look to take those firearms. Long are the days where a defendant could just give their guns to their friend or their parents. That law has been removed. Now, the only individual a defendant can give their firearms to, instead of the sheriffs taking them into their possession, is an attorney or an armory. And we are not seeing that happening much since the law changed last year in 2019. So ideally, the sheriffs will hold on to them, and while a protective order is in place, it'll stay in the possession of the sheriffs until until a protective order has expired. So when the sheriffs go to the defendant's going to receive three things. They'll receive the petition itself, which is what you indicated, facts that alleges abuse that's been committed by the defendant. It's going to include the temporary order, which is actually the signed order by a judge that tells the defendant what they are, and more importantly, are not permitted to do under the protective order. It's also going to have the notice of hearing, which indicates to them when and where to show up. It also has important information such as who to call if they need an attorney, what happens if they don't show up, which it'll tell them if you don't show up, we'll do it without you because we believe you've consented to this order. We don't have to wait or issue a warrant for their arrest. If they don't show up, your protective order will generally be granted because there's no one there to object to you. So at the final hearing, there's a few things that can happen at that point. The first is the defendant just doesn't show up despite being served by a sheriff. The sheriffs will always submit to the court what's called a sheriff's return, which tells them the date, the time down to the minute, and the location of service being provided to the defendant. That included those three documents. So if the defendant doesn't show and the court has a copy of that sheriff's return, they're going to do it without the defendant. Some those seeking a protective order may choose not to proceed with a PFA. And if that occurs at that hearing, you have the right to seek to withdraw the protective order. Some see that a defendant is getting help. Some are just honestly, unfortunately, too fearful to move forward. But we will always encourage somebody to do what they feel safest to do. But we are always here to help you obtain a final protective order. In some cases, the defendant may request a continuance of the case, either to get legal counsel or to talk to legal counsel. And we will always agree to that continuance as long as it's a reasonable request. Please note, though, that as the petitioner, the one seeking a protective order, if you ask for a continuance, there's a strong chance it may not be granted, especially if the defendant is ready to go, because the defendant is the one restrained and prohibited from taking some action. You generally are not. So the courts are less lenient and less willing to grant a continuance request to somebody who has filed the petition because they have the benefit of no restrictions against them, especially if the defendant's ready to proceed. So if that happens, if you're ready to file for protective action or protective order, be ready to go on the day of the hearing. More than likely, what could happen is what's called an agreement without admission, a final order entered by consent of the parties. The defendant is not saying he did the things that he or she did to you. What he or she is saying is that they agree to follow the boundaries that are being put up by the court, with the understanding that if they violate that protective order, he or she may go to jail for up to 6 months. If there are criminal charges pending with facts that are the facts that led to criminal charges are the same facts that led to you filing a protective order. Them agreeing to the order by an agreement without admission is not being used against them in a criminal matter. But at the same time, it does not take away the criminal charges. These are two separate actions. Only if they take a hearing and if they testify can that testimony be used against them in the criminal trial. And the court will always notify the defendant of that risk. But if they come to an agreement without an admission, it is not having any impact on their criminal matter. And as I just alluded to, if a defendant cannot agree or what you're seeking is not any way agreeable or negotiated with the defendant, a hearing could be held by the court where you, the petitioner, must testify as to what happened. And if you have any witnesses, if you have any exhibits such as pictures or text messages, or anybody who saw what happened or heard what happened, they would testify to convince the court that there was a need for you to have a protective order in place. The defendant may also put on their side of the case, including questioning witnesses and presenting their own evidence to convince the court that they don't want a protective order. And then the court will decide whether the law supports a protective order being granted. So the law allows for a variety of different reliefs that you may request in your protective order. The one that is in every order is that it'll refrain a defendant from stalking, harassing, or abusing you, or doing something that makes you believe they're trying to do one of those things. Again, you can ask the court to prohibit any contact with you or somebody who's a protected party at any work, schools, businesses, including having third parties pass on messages for them. Now, a lot of times when I have clients with children, we will always carve out an exception to allow the parties to communicate only when it's absolutely necessary. But when you have children together and we want you to co-parent from a distance, we may offer language such as a text or email only about the children. That way it's in writing. You do not have to worry about he said, she said, and it's direct proof. So that if your defendant violates the order, you can show that violation to the police, and it's pretty obvious at that point. You can be granted exclusive possession of the shared residence, as we had discussed earlier. But please note, if you moved in with the abuser 2 days before you filed a PFA, you're probably not going to get that residence for 3 years. They're going to do what they believe is reasonable. If you've lived together, if you have children, you've been in the same residence for some time, then they will remove the defendant and either keep them out for the entire duration of the order or require the defendant to give you light housing, meaning they have to give you another apartment that's similar to that. They can't just stick you in a Motel 6 hotel room for 3 years and pay for that room. It has to be light accommodations. The court can put in a temporary custody or visitation order for the children. The court does not want to litigate a custody case, but we realize that there are important terms such as where exchanges may need to occur, how the defendant sees the children, if they can communicate with the children during this order, but something temporary until either of you go into a custody conciliation in a custody court to have the long-term order. If you go into a custody hearing or custody conciliation after the final order or any protective order is granted, that custody term will trump any conflicting terms in the PFA when it comes to custody, because the most recently entered in time is always the controlling document. As we said, you can relinquish a defendant's firearms. They do have the right to try to negotiate to keep them in limited circumstances, such as if they are in law enforcement or if they need it for work. The court will permit you to seek reasonable losses paid by the defendant as a result of the abuse. But if there are criminal charges that have resulted as well based on the facts, the district attorney will normally seek those in what's called restitution. So make sure you tell the district attorney the losses you suffered, including any medical expenses, including co-pays or your deductibles, any lost wages from work, including having to file, go to your ex parte, have the final hearing. Things of that nature can be repaid. There are also special funds out there, including what's called VCAP, or the Victim Compensation Assistance Program, to assist victims with getting some money back in their pockets so you're not at a total loss. It is not 100% recuperation of your losses, but something to help out while the state is trying to recover those losses for you through the criminal or the civil matter. The order can also prevent the defendant from damaging, destroying, or disposing any property that's owned by the both of you or solely by you. So even if you're not married, but it's yours together or you bought it while you've been together, the court will allow or will prevent the defendant from destroying your stuff. And then as the next two indicate, it'll allow for you to be able to go and get the stuff. Whether it's we have them deliver it to a certain location or a third party obtains it for you, or that law enforcement accompanies you to go get the stuff, basically is there to ensure the defendant does not do anything while you get your stuff. If you believe a defendant or your abuser has violated a protective order, call the police. I cannot encourage people enough not to let things go, because if you let it go once, they will make that little, you give them an inch, it'll turn into a mountain. If somebody is threatening to hurt you, if they say they're on their way, or if they are physically there or you see them outside, call 911. Tell them you have a protective order. Explain what's happening and tell them, I'm scared for my life, and they will normally dispatch law enforcement right away. If you've received a message, if it's a 2 a.m. message says, I love you, I'm sorry, or it looks like they butt dialed you, call the local non-emergency number. Don't call 911 and explain what occurred. If it was an absolute accident, like a butt dial, they're probably not going to be charged with a violation. But if they're talking to you the way they're not supposed to, and it's clear they're not allowed to do what they're doing, the court can charge them for violating the order. What happens if they violate is what's called indirect criminal contempt, or ICC. While your protective order is civil, violating it is a criminal charge, and the defendant can be sentenced up to 6 months in jail and up to a $1,000 fine per incident. If they violate it, that is one way that you can seek to extend your protective order. So if they are charged criminally with violating your order, and if they either plead guilty or are found guilty by the court, and if you ask the court to extend your order, the court must. The language is they shall extend for an additional term. The courts have not defined what an additional term is, so it'll depend on your court. But what we have seen in our practice is most courts will just restart your clock. Meaning if you obtained a 3-year order and a year from now the defendant violates and you seek an extension, more than likely you will be given a new 3-year order the day he's sentenced or she is sentenced for violating the order. If there's no criminal trial or the defendant is not arrested, but they've definitely done things since an order has been granted, and you're concerned as to that behavior before this order is about to expire, you can petition the court and explain what has been happening, and it's within the court's discretion whether or not they will grant you an extension of your order. If they have completely left you alone, stuck their head in the sand, the hope is you are no longer fearful and you don't believe you need protection anymore. But if you wish to extend your order, you always have the right to request an extension. I would encourage you that if you are seeking an extension, do so about 3 to 4 weeks before your order is to expire, just so that there's no lapse between when a hearing is and when your order may actually expire. The law does require the court to keep your order in effect from the time of expiration until they can hear your hearing on extending it, but sometimes the court forgets to put that in the database to ensure it remains in effect. So give yourself and the court time, ask for an extension about 3 to 4 weeks before it's about to expire. Finally, the last way it can be extended is if the defendant is or was incarcerated within 90 days of you seeking your extension. So if they were released 90 days before you seek your extension, or they are about to be, or they have been incarcerated in the last 90 days, you don't have to show they've been abusive. You merely just have to show that they've been incarcerated or released from incarceration. And under that, the court will generally extend your protective order. So that is obtaining a protection order in Pennsylvania. I would encourage you that if you are a victim of domestic or sexual violence, look for help, get help out there, especially right now with the pandemic that our globe is facing. it's on the rise. And if you don't ask for help, we're not able to do anything. Uh, there are plenty of sources available, including us here at MidPenn. And I would encourage you to call our 1-800 number. Again, it's 1-800-326-9177. My personal information is on here should you have any questions, but I'd also encourage you to go to our website at www.midpenn.org for additional information, or if there's other legal matters that we can assist you with. So I hope this presentation has been beneficial for everyone. I wish you and your family the best, and I hope that you are all safe. And if we or any of our staff can assist you, please reach out. Thank you.